Good afternoon, everyone, and welcome to the first lunchtime webinar in the Discussions in Dispute Resolution series. My name is Dr. Mary Tumulty, and I'm delighted that the School of Law, in partnership with the Chartered Institute of Arbitrators Ireland, are hosting these events with the support of the National Forum for the Enhancement of Teaching and Learning in Higher Education. Without further ado, I'll pass you over to the chair of today's session, Mr Martin Waldron BL, Chairperson of the Chartered Institute of Arbitrators Ireland, who will introduce today's speaker.
Thanks very much, Mary. Likewise, we're delighted to be partnering up with UCC on this series of lunchtime webinars. And today we have Penny McRedmond talking. She's a UK solicitor and a US lawyer, certified mediator, and the author of Mediation Law, A Guide to the Law in Ireland. And rather than trying to say how great that is myself, I'll just quote from Tim Boucher-Hayes and Denise O'Connor on their comments to that book. Cogent and assured, this accomplished book by Pauline McRedmond is a well-crafted and constructive contribution to discourse on the law on mediation in Ireland. Miss McRedmond's style of writing is fluid and precise, which makes to our way of thinking for a winning combination. I don't think you could get a greater endorsement of a book than that from two leading practitioners of law in Ireland. So today she is going to be talking on confidentiality, mediation and the Mediation Act 2017. So we'll leave questions until the end, but if you could, as Penny is talking, if you want to put the questions in the chat section, I'll put them to Penny at the end. Penny, over to you.
Good afternoon, everyone. Welcome. My name is Penny McRedmond, as you just heard, and not Pauline McRedmond, as the review said, which I remember at the time being offended by. I've been asked here today to speak about mediation, and I chose to speak about confidentiality, mediation, the Mediation Act 2017. Having been given 15-20 minutes to talk, it's not very long, I thought I could most profitably use this short time by looking briefly at the Section 10 mediation privilege and the exceptions to it in the Act. So confidentiality is often cited by mediators as essential for mediation to be effective. The Law Reform Commission, in its 2010 report, agreed the privilege protecting mediation confidentiality would enhance the administration of justice by facilitating full and frank disclosure and communication between disputing parties. Following on from this, the Law Reform Commission recommended that a mediation privilege should be incorporated into the proposed Mediation Act, but that certain statutory exceptions should apply. Section 10 of the Mediation Act sets out these protections. And in Section 10, it states that subject to subsection 2 and Section 17, that all communications, including oral statements, and all records and notes to the mediation shall be confidential and shall not be disclosed in any proceedings before a court or otherwise. So you can see that Section 10 gives us a broad-based confidentiality privilege, albeit only to mediations covered by the Act. It is more expansive than privileges held by other professional relationships, for instance, for those between a doctor and a patient or a lawyer and their client. These privileges merely restrict the actions of the doctor or lawyer and not the client or patient. The mediation privilege in Section 10 is different in that it extends to everyone who takes part in the mediation, the mediator, parties and third parties, such as lawyers, experts or supporters of the parties. The privilege protects all communications relating to the mediation. Therefore, communications made prior to the formal mediation or after completion of the mediation will be protected, as will communications to try to reconvene a failed mediation, letters instructing experts, telephone calls between the mediator and parties, and text and social media between the parties or between the mediator and the parties themselves. Note also the breadth of the privilege. Section 10 provides that communications shall be confidential and shall not be disclosed in court or otherwise, extending this confidentiality beyond a privilege against testifying in court to proceedings before other bodies and as far out as informal conversation between any participant in the mediation. So under Section 10, any party, mediator or third party to a Mediation Act mediation can refuse to disclose a mediation communication. and can prevent any other party disclosing a mediation communication. The privilege belongs to all parties to the mediation and can be protected by them all. That is, of course, unless one of the numerous exceptions applies. The mediation giving this broad privilege and then just as quickly reining it in. So let's have a look at these exceptions. They're set out firstly in subsection 10.2. The first one of these exceptions in section 10 states that where a disclosure, that the mediation privilege in section 10 will not apply where a disclosure is necessary to implement or enforce a mediation settlement. This exception raises questions as to how far a judge may go in lifting the veil of mediation confidentiality in order to decide what is necessary for the judge to see in order to implement or enforce the mediation settlement. It is conceivable that a judge would feel empowered by this exception to look at privileged mediation communications between a mediator and a party, either made in open session or caucus, particularly where any settlement agreement is not comprehensive on the terms of the settlement or its implementation. This exception should serve as a warning to mediators to ensure that a mediation settlement covers all aspects of the agreement between the parties and the exact terms of its implementation, denying a judge the temptation to delve deeper and to call a mediator or a party to court to give evidence. Moving on to the second exception in section 10.2. This exception provides that the confidentiality provisions in section 10 will not apply where disclosure is necessary to prevent physical or psychological injury to a party. So a mediator, a party, or non-party participant would not be bound by section 10 if they felt that a party was in danger of physical or psychological harm, and that this potential harm could be prevented by breaching the confidentiality of the mediation. Note that the exception applies to a party, so if the potential harm was to a third party not involved in the mediation, or to a mediator or a third party participant, a different exception would need to be relied upon. This exception is really focused on the immediate danger of harm and would therefore rarely be relevant to a mediator giving evidence in subsequent court proceedings, as the breaching of confidentiality sometime after the mediation would be unlikely to prevent physical or psychological injury arising out of the mediation communication. The third exception is important, and it provides that the mediation privilege in section 10 will not apply where disclosure is required by law. And it's important for all mediators to know when they have a statutory duty to disclose information they receive in confidence in a mediation. In particular, all mediators should be familiar with the provisions of section 19.1 of the Criminal Justice Act of 2011. Section 19.1 states that a person, which could be a mediator, shall be guilty of an offence if he or she has information which he or she knows or believes might be of material assistance in A, preventing the commission by any other person of a relevant offence, or B, securing the apprehension, prosecution of or conviction of any other person of a relevant offence, and fails without reasonable excuse to disclose that information as soon as it is practicable to do so to Ongada Shikona. The Schedule 2, the 2011 Act, lists the relevant offences to which this Act applies. And there's a long list, and it includes a number of company law offences, including, for example, a company improperly providing financial assistance to the purchase of its own shares. It includes theft, it includes fraud, it includes bribery, it includes a number of consumer protection offences and a number of competition law offences. Liability can be avoided if there is a reasonable excuse, and that the reasonable excuses include the fact you don't have to self-incriminate yourself. So if the mediator was the offender, that they wouldn't have to report themselves. Or if the information is already in the public sphere, or there are physical or practical difficulties in reporting. What's important to note is that the information, this relevant information, may well be privileged when it's in the hands of lawyers for the parties. But if this relevant information is then disclosed in the course of a mediation, this would appear to impose a duty on the mediator to make disclosure in accordance with section 19. And failure to disclose could open a mediator up to potential criminal prosecution. This is a real risk and also a clear disadvantage of mediation in disputes which may contain elements of alleged impropriety, fraud, or improper conduct. In addition, mediators, particularly those practicing in the family mediation field, should be familiar with the reporting requirements under the Criminal Justice Withholding Information on Offences Against Children and Vulnerable Persons Act of 2012. Here again, a mediator could potentially be guilty of a criminal offence if they knew or believed a serious crime had been committed against a child or vulnerable person and failed without reasonable excuse to inform An Garda Síochána as soon as practicable. So those are the first three. The fourth exception under section 10.2 provides that the mediation privilege in section 10 will not apply where disclosure is necessary in the interest of preventing or revealing 1, the commission of a crime, or 2, the concealment of a crime, or 3, a threat to a party. So looking at the first two exceptions here, the commission of a crime or the concealment of a crime, this would cover current and past crimes or past attempted crimes. And the exceptions are not limited to crimes committed by a party. So it could, in theory, apply to any crime revealed in a mediation. Mediation communications under this exception would not be privileged and could be adduced in evidence in subsequent litigation. Mediators need to consider their duties of confidentiality in light of this exception in both ethical and legal terms. The issue as regards the final subsection there, subsection 3, a threat to a party, is more clear cut. A threat to a party in the mediation would hopefully be apparent to the mediator. And it is clear in this situation that the protections of section 10 would not apply and the mediator or a party could testify or be made to testify in court as to the threats. And this section does not cover threats to the mediator, which is unfortunate. The final exception under subsection 2 relates to media misconduct and provides that the section 10 mediation privilege will not apply where disclosure is sought or offered to prove or disprove a civil claim concerning the negligence or misconduct of a mediator during the mediation or a complaint to a professional body concerning such negligence or misconduct. The aim here being to protect people who use mediation services from the mediator using confidentiality as a shield to avoid sanction for their failings, while at the same time enabling mediators to defend themselves against such accusations. So those are the exceptions under section 10.2. Turning now to section 17, this in essence is an extra exception to the section 10 mediation privilege. As you recall, section 10 stated that the mediation privilege is subject to subsection 2 and section 17. So let's have a look at section 17. This provides that following an invitation by the court to mediate under section 16.1, where the parties concerned engaged in mediation and subsequently apply to the court to re-enter proceedings, the mediator shall prepare and submit a written report to court. Firstly, it should be noted that the duties on a mediator report to court under section 17 only arise after an invitation to mediate from the court under section 16. This in itself is controversial. As the Law Society stated in its submission to the mediation bill, people end up in mediation from a number of avenues, for instance, pursuant to an ADR clause or on an ad hoc basis after an approach to a mediator. The Law Society argued, quite rightly in my view, that people should not be treated differently in mediation depending upon how they enter the process. Section 17 goes on to state that this written report to court should either be, under section 17.1, a statement as to whether or not a mediation settlement has been reached. This is not in itself controversial. The problem arises with section 17.2. Section 17.2 states that if a mediation settlement has been reached on all or some only of the matters concerning that dispute, a statement of the terms of the mediation settlement must be provided to the court. This is where the problems arise. This statement of the terms of the mediation settlement has been criticised on several grounds. The most obvious is that it requires the mediator to breach the confidentiality of the mediation, and puts the mediator in the invidious position of having assured the parties of the confidentiality of the process, and then having to turn around at the end of the process and say, by the way, I now have to make a report to the court about the contents of your confidential settlement. The fact that the vast majority of other negotiated settlements can be kept confidential doesn't help. Mediation is, by the operation of section 17, put at a commercial disadvantage to a straightforward negotiated settlement. Section 17 creates the threat that the terms of a mediator settlement may be made public, this potentially having a chilling effect on the parties and therefore deterring them from the necessary openness required to make mediation an effective process. It is also the case that it is common for mediator settlements to contain clauses of a non-legal nature. For instance, it'd be common to have a clause that future-proofs a settlement. Also of concern would be where the mediation settlement contained information that was commercially sensitive. Section 17 has been widely criticised by mediation associations, by the Bar and the Law Society. And as the Law Society stated, this statutory reporting obligation, as envisaged by Section 17, would adversely affect a solicitor's willingness to act as a mediator and most parties' willingness to engage openly and frankly with each other and the mediator in the process. Various proposals to ameliorate the provisions of Section 17 have been suggested, from a simple statement to the court that a settlement has been reached without outlining the terms, to incorporating within the settlement negotiations an agreed statement of settlement terms to be submitted to the court. In its first iteration, Section 17 required the mediator to also make a statement as to whether the parties engaged fully in the mediation or not. While this would have been disastrous for a mediator's impartiality and the confidentiality of the process, at least you could see the purpose the Act was aiming for, essentially to penalise on costs those parties who did not engage. But as it stands, Section 17 seems to be all downside and without offering any discernible benefit. Having had a quick look through the exceptions to the mediation privilege of Section 10, I'd like to conclude this lunchtime with a couple of general observations on the mediator's role as regards confidentiality and mediation. Confidentiality is obviously important to mediation. It's primarily to introduce a sense of security for the parties during settlement discussions, often to reassure the parties that no other party will damage their on-the-record legal case by what is disclosed during mediation. Confidentiality also reinforces the trust in the mediator and the mediator's impartiality, enabling the mediator to be the honest broker. If a mediator discloses confidential information received in the mediation, even if they've been ordered to do so by a judge, the party who felt that their confidence had been breached would be justified in feeling that the mediator had not acted in an impartial manner, this leading inevitably to a lack of trust and damage to the mediation process. As you know, it's standard practice for the agreement to mediate to contain clauses asserting the confidentiality of the process, and for the mediator to reinforce this idea in their opening statement. Indeed, in much mediator training, confidentiality is the most commonly heard word. A standard clause in use in Ireland, which took me 2 minutes of strolling around the internet to find, states that in an agreement to mediate, this mediation is confidential to the parties, their advisors and the mediator, and everything that happens in the mediation process is confidential, except as the parties agree in the mediation. Nothing that happens in the mediation can be repeated or used in any court, tribunal, or other process, investigation, or disciplinary proceeding. Though, as we have just seen, with regards to the confidentiality protections in Section 10 of the Mediation Act, it is not the case that everything that happens in this mediation is confidential. And as a consequence, mediators should be mindful of this overpromising. Suffice to say, this type of all-embracing confidentiality clause has to be measured against the reality of actual confidentiality permitted by statute and the common law. Where a party is not informed of any potential limits on confidentiality, they could argue, quite rightly, that they have not given informed consent to mediate, not being aware of the potential limitations on the confidentiality of the process. Other confidentiality clauses do recognise limitations on confidentiality, with standard disclaimers such as mediation is confidential except where disclosure is required by law. I would argue that even this type of clause does not go far enough, and that parties should be made more fully aware of the practical realities of exceptions to confidentiality in mediation should the mediation go awry. Instead of thinking of confidentiality as a blanket term introduced in the agreement to mediate and the opening statement and then put to one side, I would propose that a more nuanced and continuing approach should be taken. The mediator and parties need to talk about confidentiality, what the limits are, and what level of confidentiality the parties actually need in this mediation. I would argue best practice calls for the issue of confidentiality in mediation to be an ongoing discussion between the mediator and the parties from the agreement to mediate to the settlement agreement and in between, as well as its parameters being clearly set out in codes of practice. As Ellen Waldman states in her book, Mediation Ethics, confidentiality is seen by many mediators as mediation's most compelling and straightforward ethical imperative. If this is the case, then a mediator should acknowledge this importance by truly engaging with the parties on the issue throughout the mediation. There's obviously a lot more that can be discussed in this area or in the Mediation Act as a whole, and that I haven't touched upon today. But I hope in the brief webinar, I've been able to give you some food for thought, and I'd like to say thank you all for listening, and I look forward to answering any questions you may have.
Penny, I'd like to thank you on behalf of everybody attending, and F.C.I.Arb and UCC for that very kind of enlightening and somewhat worrying exposition of the provisions of the Act and the limitations to the confidentiality. Something that occurred to me while listening to you, and I'd have to scroll to the limitations under section 10 in relation to, so let me go. Yeah, so 10.2a, where it is not confidential, where it's necessary in order to implement or enforce a mediation settlement. On the basis that a mediation settlement is no different to any other settlement, and it's a contract and has to be construed accordingly. And having recently done kind of detailed submissions on the entitlement to view the background factual matrix in order to construe a contract, where the background factual matrix is the mediation itself, surely that just opens up that provision that, like, to enforce a mediation settlement, surely that just removes the entire confidentiality of the mediation process if you successfully argue that you're entitled to view the background factual matrix. Otherwise, there's no background. There have been a few cases on this in the UK, nothing specific in Ireland. I can see your point, but generally how it has been looked at is that if the agreement is clear on its face, then the judges, certainly in mediation terms, haven't delved deeper. But if there's any question as to whether there is actually, particularly whether there is an agreement on every issue, the judges have gone further, and even if there's an agreement on several of the issues, but there's an issue where there is a discrepancy about whether there's an agreement, the judges have felt quite happy to delve and look into, and they've fallen back on the interest of justice in order to look and delve down into that particular issue. I don't know of any situations where the judges, certainly in context of mediation, have felt free to delve back into the whole of the mediation. They have in practice generally restricted themselves to where there's kind of lacunae in the settlement agreement, or and in fact in practice, from what I've seen, into provisions of implementation have particularly caused problems in this area. Yeah. Okay. I'm just looking at the Q&A here from somebody anonymous, but there's only two there, so I'll give them the benefit of their anonymity. What do you think would happen if a mediation failed, but then a party seeks to give evidence in court which is directly contradictory to what emerged in mediation?
So if the mediation failed, and there would be no problem. They can give any evidence in court as long as it wasn't a mediation communication. So they can give evidence in court which is completely different to the mediation, because the mediation is this contained body of privacy. So that shouldn't cause a problem. Only if they were trying to draw in what happened in the mediation would the privilege protect you, and then only if that mediation was actually protected by the Mediation Act, because not all mediations are protected by the Mediation Act, obviously. So yeah, you could give completely different evidence in court. Now that might well call up someone else who's a party to the mediation, then wanting, where the problems arise with that is then the other party to the mediation then wants to draw in the evidence from the mediation to contradict that person. And that person wanting to draw in that evidence would be prevented from doing it by the mediation privilege, unless one of the exceptions apply.
Yeah, and I mean that is the benefit of mediation, yeah. But also, I mean, somebody's credibility will be undermined, but only to the parties, which isn't very unusual in any instance.
Yeah.
From Farid Arada, I hope I've got that correct. Are you saying that the courts can revisit already agreed terms? I think you may have answered that vis-a-vis kind of them looking behind the agreed terms, but the question asked is, are you saying the courts can revisit already agreed terms?
Yeah, I'm not saying that they can't actually change the terms. They can just look in behind the mediation what they're normally doing is looking to see what terms were actually agreed when it is unclear, rather than amending terms that have been agreed. They can't change the terms that are agreed. When they might inquire is when it is not clear what terms have been agreed. That is when you leave yourself open. That's when a poorly constructed mediation settlement agreement leaves itself open to challenge. And as I said, mediators should be very careful in construction of settlement agreements to prevent that eventuality, because once it's open, then there is this danger of judges delving into communications that happen during the mediation to try and work out what the terms actually are.
Another question that's in there, and it's a very broad one, but very relevant. I mean, in circumstances where, like, we haven't had a Mediation Act in the country to date, and mediations have taken place in family law and commercial contexts forever, and we've all understood the confidentiality aspects of them, and we haven't had this legislative framework to perhaps, and you find the more you write and the more you enshrine in law, the more things are perhaps become open to challenge. What would your general view be of maintaining the status quo with no act versus the introduction of the act? Do you think it's a good thing or a bad thing?
I think it's a good thing generally, but I think it was an opportunity probably missed to a large extent. And I think there's several issues that I would have. One is to the actual mediation that it applies to. For me, Section 3.2 is Section 3 as a whole is the greatest problem. Section 3 excludes a vast quantity of mediations from the Act, any with some that are listed there, arbitrations and workplace relations, and then any others with statutory dispute resolution processes already in place. And a lot of those statutory dispute resolution processes under other acts don't give equal protection as under the Mediation Act, or they give different protection. So it's kind of all over the place. And then Section 3.2 goes on and then states that the Act will also not be construed to replace any other dispute resolution process in place from any other statutory instrument or any act or any other contract or agreement, which seems to be trying to get at saying that the Act will not replace any statutory, any dispute resolution process that's previously been agreed, like from ADR agreements. So the Act will not come in and interfere with an agreed ADR process. But it also seems to go way further than that, because it says any contract or agreement, which would then imply that you pull in almost every other mediation that doesn't happen during the courts, because every mediation starts with a contract or agreement, i.e. agreement to mediate. That's a contract. So if you read the Act literally, it basically is saying that any mediation that didn't start either under further section 14, though even those could be included, or section 16.1 is not covered by the Act, because so I personally, I think that section is a complete mess, and causes great confusion, and I don't think it's necessary. And so that's on one ground. I don't think the Act in that particular context is very well drafted. And then also I think it missed a lot of opportunities for, one, regulating mediation as a whole. If mediation, wants to be regulated, I can't believe that they didn't make it compulsory that a mediator should assign themselves to a code of practice, whereas the codes of practice for mediators are voluntary under the Act. And so there's lots of things like that where, if you're going to regulate mediation, then I think they could have regulated it more comprehensively and better. Whereas here, I think they've it's kind of a halfway house, where it's not completely clear what mediations are covered, and mediation as a whole is kind of half regulated. So, do I think it's better without it or better with it? I think I'd probably be in favour of regulating it, especially in putting in place a robust mediation privilege, and various other provisions in there which are very helpful. The enforcement provision, section 11, section 14, if it actually works, the referral from solicitors, and the section 16 provisions. Some of these are very helpful and useful, but as a whole, I don't think it hangs together really well as it could have done. Does that answer that?
One of the matter that arises, it's always been there, as we've discussed this before, and it's the potential cost consequences of refusing to engage in a mediation. And while that's been in existence, it's now on a statutory footing.
Yeah.
And would you agree or disagree with the view that potentially makes this something that people feel compelled to take part in, and so it greatly undermines the voluntary basis of mediation?
Yeah, I think the unreasonableness in section 21, the use of those terms, has a major impact on the voluntary nature of mediation, and I don't think it's helpful. I don't think it is good for mediation as a whole. I think it'll force people to feel that they are being compelled to mediate, and will take away from the voluntary nature of it. It does take away from the voluntary nature of it. There's no doubt that it does. It's this great big stick that is hanging over people if they refuse to mediate. And in the definition of mediation at the beginning of the Act, it says it's a voluntary process, and then later on it says but if you unreasonably refuse to do this, you will potentially be sanctioned. So I don't think it's helpful, and I think it undermines sort of the basis upon which mediation works.
You've actually drawn attention there to the definition of mediation under the Act, which, as somebody who practices in construction mediation, and that morphs often into conciliation, the definition of mediation under the Act is it means a confidential, facilitative and voluntary process. Now, in construction matters, we don't tend to go for the facilitative, softly approach of mediation. It's far more an evaluative approach, because the parties in a construction dispute have been arguing for months sometimes. So it's not a question of getting them to sit down and understand one another's position, which is a facilitative approach. It's more, for want of a better word, a bit of knocking heads. Yeah. And that requires an evaluative approach. And I, as a construction practitioner, I don't like the fact that it is defined specifically as being facilitative. Would you have a view on that?
Well, I do actually have quite a strong view on that. Now, it does say later in the Act, and I can't actually pull up from my head, that a mediator is entitled at some point to give direction. There is that tiny little clause further on. But defining it as facilitative, I think that was in many ways a win for a particular mediation cohort in influencing the bill as it progressed through, influencing the Law Reform Commission in submissions, and also submissions on the bill as it went through. And I think that that it has defined mediation as being a very particular type of mediation, which I, certainly from my experience, is not the most commonly practiced form of mediation in Ireland. Certainly the majority, from my experience, of commercial mediations have facilitative, aspects to them, but they also have more evaluative aspects to them. Mediation is this wide range. It goes from purely facilitative to very directive, and most mediators move along that range to some extent or other, and use different tools depending upon the situation. And I don't think it was helpful defining mediation as facilitative at all. And actually, it's one of the major issues that if you drilled down, that I would have right at the beginning.
Okay, we're at it on that one. I have a question here from Katrina Kevill, who is a colleague and the chair of the Bar ADR committee, and she says, do you think the Mediation Act 2017 has given rise to a tension between legally qualified mediators and non-legally qualified mediators, or is that something that has always existed?
I think it's always existed. I think it has undoubtedly added to the tension, and I hear that tension. Certainly, I lecture in conflict dispute resolution at Trinity, and I have sort of contacts with both sides, and I definitely hear the tension. And I has the Mediation Act made it worse? I don't necessarily think so. I don't think it has. I don't think the Act itself has exacerbated that tension. I think that tension is there. I think that certainly non-qualified mediators, particularly outside the specialist realm, so we're not talking about the engineers or the architects or the things, we're talking about the employment mediators and the community mediators and people working in those sort of spheres, feel that mediation is being taken over by the legal profession, and there is certainly a quite an amount of tension about how they feel that their sort of body, their process is being shanghaied by the lawyers. I hear that a lot, but I don't think the Mediation Act is to blame. I think it existed anyway.
But Penny, it's been a fascinating discussion, and I think I could continue this anyway for at least an hour. I would love to at another time. And I think given the number of people who've attended, I think this has been very well received. And on behalf of F.C.I.Arb, I'd like to thank you greatly for your talk today. And perhaps Mary, on behalf of UCC, would just like to close there.
Thanks very much, Martin and Penny. I'm aware of the great interest in that discussion and a really fascinating talk. I think, as Martin said, this could go on for much longer, but it is intended to be a bite-sized series. So we'll wrap up there, and hopefully we'll see lots of our attendees at next week's session, where we have John Gaffney speaking on international arbitration. So thanks to Martin for chairing, and thanks very much to Penny for your insightful talk.